I hit rock bottom. I was sent to jail for driving with no license. I was living on the streets, out of the vehicle. I distanced myself from my kids, my families, and just felt drugs were more important than they were. And then I realized that since I hit rock bottom, that it was time for me to grow up and be a mom again and make better choices and show my daughter, because she was following in my same footsteps too, and to be a better mom than a friend. At first, it was a struggle. I didn't do what I was supposed to. I kind of procrastinated on getting stuff done. I ended up going into, I got sanctioned for 3 days, went back to jail, and after that is when I started straightening up and getting back on track again and getting my life back together and realizing that I wanted to be with my kids. I had staffing meetings where I went and saw my daughter in the rehab that she's in. I had time with my littlest one, my 9-year-old. I went and saw him as much as I could, watched him play baseball, just interacted with what I was supposed to do, and just did my drug tests like I was supposed to and passed them and didn't go back down that road again. Oh, I'm living back at my house again with my ex and my kids. I have a vehicle that I drive and a license. I have money when I need it. I have food all the time. Place to be with my kids, and I get to spend time with my kids a lot more than what I used to. Take the help and don't say you don't have a problem when there is a problem and you can get help. It's not over.
All right, so going into the next subject, it's really the Baker Act. And this is a question that I get the most questions about. And like Judge Leifman, when I began this journey, I thought that was my solution to everything. So I've learned a lot about it, and it is a solution, and it has worked in many circumstances. But it is obviously not everything. So I created this afternoon because it is one of the most important parts of what this issue is. And we have to know its limitations and its strengths. So we have a fabulous group of people. We're going to start out now with Dr. Mario Oliva, and he is the medical director at Coastal. So he is at ground zero for crisis and its intersection with being 51 in the country for funding. And I didn't even realize it was 51. That must mean that there's a territory above us, I guess. So, but I've been really busy lately, so maybe I missed that. Dr. Oliva is a Sarasotan, and that's what I love about him. And I met him recently, and it was like all of a sudden everything became clear. And I had a person to reach out to who was responsive, compassionate, really on the ball. I was so impressed. And then I remembered, oh, you're that guy. The star soccer player at Cardinal Mooney. I did not go to Cardinal Mooney, but I know him there. So that's how I remember him, and it was really neat to see people come home and serve in the way that he has served. So he's going to talk to us a little bit about the Baker Act from the psychiatrist's point of view.
Well, thanks, everybody. Like she said, I'm Dr. Oliva. I'm the medical director for Coastal. I've been there for quite a few years. She did make one small error on my bio. It says I was born here. Sadly, not quite. I was 1.5 when I moved here. I wanted to be closer to my mom, so, you know. I stole that from Ed. So you have to forgive me. I'm a little obsessive compulsive, so I have quite a few papers here, and she really wanted me to address quite a few issues. So if I'm too loud, sorry about that. So I'm going to go through this kind of quickly as possible anyway. So first she wanted me to address how do patients get to me under the Baker Act. So obviously they can come in voluntarily, but that's not a Baker Act. So they're Baker Acted by either police officers or mental health or medical providers, whether it be out in the community or in an emergency department or at an outpatient provider's office, perhaps. So they'll either be dropped off by police officers or they'll come to me from the social worker or an ER physician or a psychiatrist or a social worker. And they'll have to have met the criteria for the Baker Act, of course, which is either suicidal, homicidal, or unable to care for self, right? The unable to care for self aspect is up for a lot of interpretation, and that's quite often when I get individuals who are psychotic. They aren't necessarily suicidal or homicidal, but they are unable to care for themselves safely in the community. Again, we also see other processes, depression, bipolar, etc., but it's quite often schizophrenia or schizoaffective disorder. So we also obviously see a very high proportion of individuals with co-occurring disorders. I was thinking about it, and I don't have any specific numbers, but if it's less than 70% of those who come in, I would be quite surprised. Clearly, that's not average for the community, but those who come into my crisis stabilization unit, probably up around that range. Obviously, we see all different types of substances, you know, from alcohol to marijuana, lots of amphetamine recently, and of course, you know, the opiates, quite a bit of cocaine. It runs the gamut. You know, whether that's new use and they're completely taken off guard by the fact that staying up for 7 days on a methamphetamine binge can lead to psychosis, or just chronic folks who've been doing this for years. And then she wanted me to just touch on the homeless individuals, and they're very difficult to summarize. I think that's the main issue with homelessness in and of itself. If it was easy to categorize all homeless individuals, it'd be very easy to treat them, right? If every homeless individual was homeless for a certain reason, and it was all the same across the board, we could rectify that with a snap, but it's not the case. They're just probably 50 to 60% of the population that we see on a daily basis has acute homelessness, or at the very least, lack of truly supportive housing. So thank goodness for the last folks we had up here. They're really helping out a lot. Excuse me. Okay. So when you perform a Baker Act evaluation, what am I looking for? Well, I have 24 hours to see these people initially. I'd like to do it as soon as possible, of course. And what I'm really trying to figure out is whether they meet criteria for inpatient hospitalization to be continued, right? I see them, it's either they can go home or they need to stay with me a bit longer. They can stay with me a bit longer under the Baker Act, or they can be converted to voluntary status if I think they're appropriate enough for doing so. So if they stay under the Baker Act, I have 72 hours under that initial Baker Act to figure out what to do to help these folks out. It can be continued longer after I get a second opinion from another psychiatrist or psychologist, and then they get the chance to go to court, the patient does, to say, hey, I really don't need to be here, or they can agree to stay a bit longer. So simultaneously, obviously, we're at that point looking to try to find out what sort of medication might be helpful for these individuals. I'm not going to go into medications, but we have a lot of different options available. Yeah, and you know, we practice a team approach there. It's not just, okay, you see Dr. Mario, and Dr. Mario figures everything out, and then you go home, because I can't do that. So, you know, we have a nurse practitioner, we have other multiple nurses who meet in a team meeting with us every morning. We have social workers, we have therapists, and we have 2 or 3 discharge planners who work very diligently on trying to get these folks all of the services they need, addressing all of their psychosocial needs as well, whether it be housing, trying to reconcile them with their families. We do family meetings, case management, try to set up appropriate follow-up and convince them it's a good idea to do so. And, you know, obviously doing our best to link them with any other services that are available in the community. So the next question was, do we get any information from anyone other than just the patient? And absolutely. The first thing I look at, obviously, is the Baker Act, and the most detailed narrative possible is always the best. Every once in a while, I'll get a Baker Act that says depressed, suicidal. It tells me what's going on, but it doesn't give me much to go on, per se. So I always enjoy the ones written by a lot of the law enforcement officers, thanks guys, who really put a lot of effort into it. And I go, wow, this is amazing, because it gives me a lot to go on. So obviously look at the Baker Act, and then we also do our best to reach out to any sort of collateral information that might be available. Now, if the patient is deemed competent and they say, hey, I don't want you talking to anybody, I'm on my own, I've been on my own forever, this is it, our hands are tied, and that's tremendously frustrating to the families and others who might care very much about them. But alas, there's very little I can do. Now, that being said, if they're bad enough, for lack of a better term, we can deem them incompetent and seek a guardian advocate. That incompetency only lasts while they're inpatient. It doesn't continue on after they leave, so they're back on their own again. But at that point, we have the ability to reach out to whoever it is we feel could be helpful. Problem then is convincing them to give us a telephone number, but we generally figure it out. We do a lot of detective work. So we very much appreciate families' input, and we take it into very strong consideration. So my options at the conclusion of a Baker Act evaluation, again, is to deem them competent or incompetent, to sign for their medications or contact their families, and then we start working on the inpatient treatment plan of care, medications to stabilize. We have two main types of medications. We have pills or oral medications, and we have injectable medications. We have fast-acting injectable medications that can be used to treat in emergency situations. When someone's out of control, they might need an emergency treatment order, at which point we'll have to give them an injection if they won't take it by mouth. And then we have the long-acting injectable medications that are generally antipsychotics, and they are a godsend. They work between 2 and up to 6 weeks. There are also other preparations that last 3 months, and they're working on others, I'm understanding, that may last up to 6 months, which is about as close to a cure as you're going to get for schizophrenic type process for now, until we get a cure, which would be lovely, but we'll see. So we work closely with the patients, try to convince them that this is in their best interest, this isn't a punishment, we're not mad at you. Makes your life easier. You don't have to remember to take a pill. My wife sends my multivitamins in my lunchbox every day, and 80% of the time I forget to take them, and they're right on the top with a card that says, please. So you get the idea, right? So I can't imagine being someone who has a very severe and persistent mental illness trying to remember to take this litany of medications. Even if it's in a pill pack, it's just not today. Too big, too annoying, don't want to deal with it. So the injections are wonderful. Again, we're starting discharge planning from day one, right at the onset. Okay, so hey, where are you going to go? Do you have a place to stay? Is it safe? Are you stable there? Are the other individuals in the home stable? What can we do to help you out? So my best case scenario always is to try to reach out to family members if they're supportive. That's not always the case, but hey, it's worth a try. And quite often, we've made some amazing strides in that. At points, one gal hadn't seen her family in 10.5 years. Family hadn't found her. She had been lost to them. And a month and a half later, we contacted them finally, and they said, oh my God, thank goodness, finally we found her. So it's worth the effort. So sometimes they don't have family support. So thank goodness for the Salvation Army. They are right across the street from our facility. They come through in a pinch, the shifts programs, all the other programs, the supportive housing options, through Scott and everyone else. It's just extremely helpful, needless to say. Issue being sometimes they don't have financial backing at all, so we're left with Salvation Army, which is excellent. It's almost helpful sometimes when they have a dual diagnostic criteria being met, so they can enter into a program such as Viper or the CRP or some of these other programs for substance abuse and mental health. never wish them to have substance use problems, but that makes it easier because then they've got 3 months of solid stability in a safe space. So if they don't improve, we're left with some other options. You know, if their symptoms are too significant and they remain unable to care for themselves, we look towards the state hospitalization. We go to court, and again, we try to convince them that it's in their best interest, and I can honestly say that I truly believe that it is in their best interest. The outcomes that I've seen over the last 5 or 6 years with individuals entering into the state hospital system, it's not always perfect, but I have any number of extremely wonderful outcomes. There's an individual who works here who now, you know, came through that system and has more confidence than I've ever seen anyone from where they had come to where they are now. It's just shocking. So I can say that I can send them to the state hospital with complete confidence that it's going to be a helpful and appropriate experience for them. So if we end up getting them sent to the state hospital, they might remain with us for another 3 weeks, up to 2 or 3 months, waiting on bed availability at the state hospital. It's not always set and send them out. So we have time to further stabilize with the possible option of diverting from the state hospital. I must say it doesn't happen often. And my main reason behind that is if it's come to the point where I feel like you need the state hospital and my team agrees, like I said a few minutes ago, I'm fully happy with the idea that that extra level of time and effort and energy that they expend on you at the state hospital could only benefit you in the long run. So I very rarely will say, okay, you've cleared up good enough now and you've spent 2.5 months with us, why don't you just go back to where you were? Let's just continue this on, spend 6 months on the same medicine, and the turnaround is shocking at times, which is wonderful. Not always, but quite pleasing when it is, needless to say. So we're staying in contact with Central Florida, and Pam Carter will talk about that. Paula. We'll talk about that a little bit later, but we stay in contact with Central Florida to talk about the diversion options, but again, generally, the outcomes are so good with the state hospital that I wouldn't even want to necessarily do that if we can avoid it. Am I about? Okay. All right, so long story short, I'm Dr. Oliva, so any questions you guys have about any of this stuff along the way, throughout your processes, feel free to contact me at Coastal. I'm happy to answer any questions. I'll meet with anybody that needs to chat, and we'll go from there. Thanks.
All right, Ed Wilson, our next speaker, is a 1980 graduate of Duke University with a BA in history and a 1983 graduate of the University of Florida College of Law. In addition to private law practice, Mr. Wilson has served as Assistant County Attorney for Sarasota County and is currently Senior Court Counsel for the 12th Judicial Circuit Court, and also serves in Sarasota County as Magistrate for Marchman Act and Baker Act involuntary treatment proceedings.
Thank you, everyone. I want to say that unlike Judge Denkin or Major Bell, I'm not afraid of Judge Quartermain, but I like her a whole lot, and I know she's put a lot of blood, sweat, and tears into this program today, so I'm going to really try hard to finish on time. And I know that if I not do well with that, she'll give me the hook anyway, so, because she runs a tight ship. Okay, first of all, what's a magistrate? You've had a lot of judges up here today, including Judge Leifman and Judge Quartermain. A magistrate is appointed by the chief judge to hear different areas within certain jurisdictions. The Baker Act permits the circuit court to appoint a magistrate to hear these contested Baker Act cases. So our judges have a lot on their plates. We have magistrates in the family law division. We have a general civil magistrate who hears certain contested matters that are in civil court. So it's not uncommon for courts to use magistrates. We are attorneys. I went to law school. I work full-time for the court system here. I'm in a position called court counsel that Judge Quartermain used to be in. In fact, that's where I met her. In 2007, we were working in the same office and doing the same sort of work. She's now moved on to county court work. And I will say she's doing a fabulous job. And I want to say also, I grew up here in Sarasota, all the way kindergarten, elementary school, middle school, high school. My only time away from here has been going off to college and law school and then coming back. And I've seen these huge changes. And one of them, and it's very heartwarming to see the community approach to addressing mental illness and homelessness. The folks who are in that situation, those situations, are probably the most vulnerable and most misunderstood in our community. And there was a point in time in the distant, not too distant past where they weren't even regarded at all. So it's heartwarming to me as a lifetime resident of Sarasota to see a turnout like this and to know that we have folks on the policy side working on these issues. Mental illness is coming out of the shadows and getting treated and addressed in a way that it really should have always been, but we progress as a society, I suppose. Okay, so I'm going to talk about the area of the involuntary inpatient placement. I'm going to pick up where Dr. Oliva left off. By the way, Dr. Oliva frequently is a witness in the hearings that I conduct, and I'm very familiar with him, and he does a fine job too. The way I get involved as my portion of the judiciary is, as Dr. Oliva said, a patient is there, in his case at Coastal Behavioral Health Care. I also go to Bayside to have these hearings. Oh, by the way, we have the hearings at the hospitals. No one is transported from a facility to the court. We go to them. I go Thursday afternoons, that's hearing day for Baker Act. And I ride in a van with a court services deputy and a deputy clerk. I carry along a little digital recorder because it is a court hearing. I'm going to record everything that happens during the hearing. And if someone wants to appeal the result of the hearing, there's a record for that. The patients have civil rights and due process rights. And that's what the hearing really is. It's a due process determination of whether or not the person meets the Baker Act criteria. So typically, when the hospital makes the determination to file the petition for involuntary placement, a few things start happening in the court system. That petition is sent to the chief judge. The chief judge sees it. Chief judge appoints counsel right away for the person. The public defender is appointed to represent anyone who can't afford an attorney of their own. A person can have their own attorney, but usually the process happens very quickly, and if someone has means to hire an attorney, it happens very rapidly, and they may not have time to go out and procure their own attorney. So the public defender gets appointed to represent the patient. The state attorney is informed. The state attorney's office steps in, the state actually steps into the shoes of the petitioning hospital. At that point, it's the state as the petitioner and the patient as the respondent. We don't say plaintiff or defendant. This is a civil procedure. It is not criminal. So it's not punishment. It's a due process hearing to see whether or not this person meets the Baker Act criteria. And we have this in place because there's a loss of liberty at stake. Everyone in this room has a liberty interest, the right to be free, to go about your day-to-day business. So the system only takes that liberty away if there's good reason to do it. And that's the criteria under the Baker Act. So to set the stage for you, I go to the hospital. We meet, usually it's a fairly large conference room. The patient comes in. The patient has a chance to consult with his or her attorney. The attorney will talk with anybody else who might be there on behalf of the patient, such as family members, Members of the FACT team are sometimes there, not always, but if they're involved, frequently there's someone there. Caseworkers, social workers. Of course, both attorneys speak with the psychiatrist, sometimes together, sometimes separately, just to try to get an idea of the person's situation and what's going on with them. One thing you need to realize, and the lawyers in the room will appreciate this, the attorneys who handle these cases, they're basically handed the file just a few minutes before the hearing begins. So they don't have the luxury of what lawyers call discovery, where you get to really drill down into a case and take depositions and look at documents. Things happen fairly quickly. And one reason why they happen quickly is because you don't want to keep someone at a hospital if they don't need to be there any longer than necessary. Dr. Oliva told you that the decision is made within 72 hours whether this person's going to be discharged or whether they're going to file the petition for involuntary treatment. So I get involved with those hearings once that decision has been made to file the petition. So we begin the hearing. Everyone's put under oath who's going to testify, and the primary witness is the psychiatrist. The psychiatrist will speak about their history, the history of the patient, their clinical history. Frequently, the patients are very familiar to the doctors, people who have been there several times. Sometimes it's a brand new person they've never seen before. So they get behind the eight ball a little bit, the doctor does, trying to get a history from family, friends, somebody else. The doctor will look at the paperwork that comes in with the patient. If law enforcement has transported the person in to the hospital, under the Baker Act, they're required to fill out a transport form that includes lots of information, or should include lots of information about that person's situation, on what circumstances surrounded their coming into the law enforcement custody and coming into the hospital. The doctor is required to look at that. That's part of the process of reaching a diagnosis, whether or not this person has a mental illness. So the evidence is presented, each side gets to argue. The patient has the option of speaking. They don't always want to speak. Sometimes the patient doesn't want to come to the hearing. We try to assure them that they're not in trouble and it's not punishment, but we're trying to make sure that they need services and help. But they're usually there. Frequently they do testify. They can, frankly, sometimes hurt their situation or sometimes help it by giving me information that's useful. At the end of the hearing, when all the evidence is closed, I make a ruling right there on the spot. I explain to everyone whether I find the person meets criteria or not, and what the disposition will be. I really want the patients to understand what the process is, and I try to take time to explain that to them. I don't know if they always track exactly what I'm saying, but they have then the option. One thing to understand about a magistrate is I don't enter final orders. I enter what are called recommended orders. So I fill it out on the spot, I sign it, it then goes to the in this case it is the chief judge, Judge Williams. He's the probate division judge. In Sarasota County, Marchman and Baker Act come under our probate division. So he then signs those orders, and if the person is going to stay longer at the local facility, the order will provide what the diagnosis is, what the findings of the magistrate are, and the length of time they'll have to stay there. And it's up to a certain date. So the important thing to remember is, even though there might be a court order in place that says you will stay here 2 more weeks, if the doctor decides in 3 days that the person no longer meets criteria, then the doctor is required to discharge the patient from the facility. It's not that the hospital needs to go back to court and get a second follow-up order, amended order. It truly is a psychiatric medical decision. It's not a bunch of lawyers and judges sitting around deciding whether this person should be released early or not. It's a medical decision. Now, if someone is ordered at the end of a hearing to go to a state mental health facility, that order is entered. That can be for up to 6 months. Once a person, by court order, has gone to a state mental health facility, it then stops being a local decision for their disposition after that. If they're at the hospital and the doctors there think the person requires more hospitalization, they file what's called an administrative proceeding. It's a whole different arena. It comes in front of an administrative law judge who makes a decision on whether or not the person should stay longer at the state facility. A commitment locally here to one of the hospitals locally can be for up to 90 days. But for things longer than that, it would be up to 6 months. And it's possible that if the hospital believes the person needs more treatment, they can petition the administrative law judge for a longer commitment. So I keep talking about criteria. What is the criteria that I would look at to determine whether or not somebody needs hospitalization under the Baker Act? And I hate doing this because I hate when it's done to me, but I'm just going to read you what the statute says. I'd ask you to bear with me on this a little bit. It's kind of a mouthful, but it provides a person meets the involuntary placement criteria if the person has a mental illness, and because of mental illness, he or she has refused voluntary inpatient placement for treatment after sufficient and conscientious explanation and disclosure of the purpose of inpatient placement, or he or she is unable to determine whether inpatient placement is necessary, and he or she is incapable of surviving alone or with the help of willing and responsible family or friends, including available alternative services, and without treatment is likely to suffer from neglect or refuse to care for himself or herself, and such neglect or refusal poses a real and present threat of substantial harm to his or her well-being. Or there is substantial likelihood that in the near future, he or she will inflict serious bodily harm on self or others, as evidenced by recent behavior causing, attempting, or threatening such harm, and all available less restrictive treatment alternatives that would offer an opportunity for improvement of his or her condition have been judged to be inappropriate. That's the standard. Now, I like to boil things down, simplify them down in my mind, and I take that as, A, the person must have a mental illness. That's where the diagnosis of the doctor comes in and the testimony that's received from the doctor and a recommendation of treatment. But also, there must be something else besides mental illness. And I want you to notice what that standard didn't say. It didn't say mentally ill and annoying, or mentally ill and inconvenient, or mentally ill and generally disturbing to the people out in the community. It doesn't say that. There has to be evidence put on and a finding made that some harm is likely to come either to the person, him or herself, or that person is likely to cause harm to some other person. Now, it doesn't have to be death, but substantial harm and injury has been regarded by the courts as something serious enough to require medical care and medical attention. Now, some of these cases are pretty straightforward and easy to determine. And I'm going to give a couple of examples. In the self-harm area, if someone has been brought in and they recently tried to commit suicide and they are brought in by law enforcement, they've been pulled from the brink and they're there, that's a pretty direct case for me to hear and to make a determination that the person meets the criteria. There's other kinds of self-harm. I had a gentleman in front of me once who, and I've been doing this for about 9 years, and I'm not just going to list through a whole bunch of what I've seen, but just to give you some examples. A gentleman diagnosed with schizoaffective disorder, part of the way his condition manifested itself was something called polydipsia. And the doctor explained to me that that's basically compulsive, uncontrolled consumption of liquids. There is such a thing as water intoxication. You can die, believe it or not, if you drink too much water. It throws off electrolyte balances in your body. It can affect your heart function. This gentleman had to be hospitalized for that. That's something that wouldn't naturally occur to me, and probably many of you here in the room. But that's the kind of self-harm that a person needs to be protected against. This gentleman could not stop doing that, so he needed to be in a setting where he could be supervised and kept, not rationed water, but kept away from situations where he could just uncontrollably drink. I had a young woman one time who was diagnosed with borderline personality disorder. She had spent a number of years as a very small child in an orphanage in a foreign country. I don't know what sort of trauma she may have suffered, but she manifested her PTSD with swallowing sharp objects. She would swallow fish hooks, pins, razor blades. Every one of those situations could have killed her, perforated her bowels or anything else. That's a situation where someone needs hospitalization to be protected from themselves. Of course, another way that a person could cause harm is a threat to other people or causing harm to others. I did have a gentleman one time also suffering from PTSD. He had, his history was he had been sexually abused by his natural father as a small child. He was out of that setting. This man was in his early 40s, and he told me during the hearing, about 2 weeks earlier, the terrorist attack on Bastille Day in France had happened, where the truck was driven along the waterfront and many people were run over and killed. This fellow came into the hearing and said he had seen that. He thought that was a great thing to do. When I get out of here, I'm going to steal a car. I'm going to drive down Main Street in Sarasota. I'm going to go up on the sidewalk and run people over. I'm going to go out to St. Armand's Circle and do the same thing. People need to suffer the way I've suffered. That's what he told me. He was very direct. He was very credible. And I believe that was a direct, serious threat to the safety of other people. So he was found to meet the criteria and was ordered to go to a state mental health facility. Now, those are the more direct, simple cases. I don't want to say simple because we're talking about human lives here, but those are obvious. Those are direct. The area that I think probably has the most relevance to the general theme of today is homelessness and mental illness are the people who come under the category of, well, they might suffer from neglect. And those are the more difficult cases. Those take more time. How do you prove that? I want to give you a couple of examples of real cases, not that I presided over, but these are early on in the earlier years of the Baker Act. One is called Neff versus State. Mr. Neff went into a restaurant, ordered breakfast, ate it, and then told the staff there that God would pay the bill. And they didn't like that at the restaurant, and they called the police department. The police came, appeared to recognize that this gentleman had a mental illness, something was going on. They took him to a hospital. He was evaluated. They did have a hearing for his placement. The doctor testified that he was extremely intelligent and a paranoid schizophrenic. And I have a quote from the doctor. The doctor felt that with treatment, there was a high possibility that he could come back into the world with his capabilities. An order was entered committing Mr. Neff to a facility. Mr. Neff appealed this, and the appellate court looked at the record. Remember the digital recorder I used? Looked at the record and found there was no evidence presented at all that Mr. Neff was unable to care for himself out in public and in freedom. So yes, he might go into a restaurant and order food and not pay for it. That's annoying to the restaurant owners, but there was no evidence presented that he would suffer from neglect if he was set free. So his commitment was reversed, and he was discharged from wherever he might be held. Now, probably by the time that case made its way up through the court system and became an appellate case, I don't know for a fact, but Mr. Neff was probably already discharged and was out doing what else he was doing, hopefully using his intellect and getting treatment and getting back to day-to-day life. A second case is called Salter v. State. And this one's a little better, but it also ended up in a reversal by the appellate court. There was one witness in that case, and that was the doctor. And the doctor testified that Ms. Salter was not cooperating with the recommended treatment, and that she had schizoaffective disorder, medication was needed. But the appellate court noted that there was no evidence put on, the doctor even said that Ms. Salter would suffer from neglect, but went no further, didn't get specific. So the appellate court reversed that case as well. What I'm trying to get at here is we need specifics, and the attorneys who handle these cases are trained to draw out the specifics. In those two cases, I wouldn't have blamed the doctor, because the doctor's testifying from the medical standpoint. I would have really blamed the attorneys and probably the judge for not, or the magistrate, for not getting the right evidence into the record so the court could make the proper decision. So what would I look for in the area of neglect, and what to prove that a person might suffer from neglect? Well, does the patient have physical wounds, anything that they've suffered recently when they're out going about their day-to-day life? Do they appear malnourished? Do they appear dehydrated? These are situations that can quickly arise and be life-threatening when it comes to neglect. I also bring out during the hearings from the doctors whether or not a person has any other medical conditions they need to be treated for. They might have high blood pressure, they might have diabetes, COPD. There could be other medical issues that they have, and they need to have treatment for that. If they can't take care of themselves, they may suffer and die from that. Another thing to look for is how do they handle their activities of daily living? Medical folks call those ADLs. Bathing, eating, toileting, those are indicators that a person may suffer from neglect. So I want to conclude by saying that the rule we follow in the court system is if a mentally ill person who is non-dangerous to themselves or others and can care for themselves adequately with perhaps help from others out in public, that person should not be involuntarily hospitalized, because that's not what the Baker Act is for. Thank you. That's all.
All right, so the next speaker we have is from the Central Florida Behavioral Health Network. So she is the admission and discharge liaison for the Civil State Hospital and the program manager for FACT. So we've all heard about the state hospital. How many of you have been to one? A few of you, okay. So it is sort of always been a mystery to me. So I'm very, very excited about her presentation. She has been in the behavioral health field for 37 years. She has worked in a variety of settings and been exposed to a variety of different individuals. It was, development and implementation manager of special grant funded programs, the mental health overlay, caretaker training program, CSU inpatient social services director, adult mental health outpatient, and the list goes on. And like I said, for the sake of brevity, I distributed the biographies earlier. But I know that she has been an advocate. I listened to a story with her and Mark Engelhardt going back to the mid-'80s where they were in court about these facilities. So she's really a historian in this regard. She's got her thumb on the pulse. So I'm excited to hear from you.
that? The lady in the red? Well, good afternoon. I'm Paula Carter, and I'm with Central Florida Behavioral Health Network. And I made a mistake. I brought the wrong glasses, so I can see, but I can't see you, which is probably good. Probably a perk. Okay. Well, I'm here to talk about the civil state hospitals and the process. Just to give you a little bit of background in terms of Central Florida Behavioral Health Network, we cover 5 circuits, and that includes the Suncoast region and Circuit 10, which is part of the Central region. You can just hold that right there. I'm not there yet. We cover 14 counties, and we deal with 3 civil state treatment facilities. We have 14 FACT teams, and the civil state beds that we have access to in the state of Florida are a little over 1,400 beds. So going from there, I'm going to go ahead and start just going through this, and I'll give you some more data a little bit later. We have 3 state hospitals that we deal with. Florida State Hospital is Chattahoochee. It's outside of Tallahassee. And that hospital contains one of the few facilities that has both civil and forensic. And the beds number for civil is 490 beds. They serve circuits 6, 10, and 13. Okay. This is the hospital that serves Circuit 12. It's South Florida State Hospital. It's also called Correct Care, which is it's one of the privatized hospitals in the state of Florida. It's located in Pembroke Pines. It has 335 civil beds, and for us, from our area, takes Circuit 12 and Circuit 20 clients. Okay. Then there's Northeast Florida State Hospital. We do not admit anybody there, but the state hospitals like to play tricks on you sometimes, and what they did was Florida State Hospital moved people that were in their hospital to Northeast Florida State Hospital. So now we have case managers going all over the place to track and I get to do discharge planning with 3 state hospitals. This hospital is 663 civil beds, and I already told you that. Okay, next one. Okay, the referral process, and some of this has been hit on, so I'll try to be brief. But we have local receiving facilities that we get referral packets to the state hospital. Receiving facilities are either public or private. The public are your CSUs, and in Circuit 12, that's that's Coastal and Centerstone. You have 5 receiving facilities in Circuit 12. 3 are private, and then you have Coastal and Centerstone Hospital, and then Centerstone CSU is the other public. Let's see. The individual is admitted for a psychiatric exam, and let's see here. Can't really see. Wait, go back one second. Okay, they're either going to be admitted to a receiving facility. They actually could sign themselves in as a voluntary if they wanted to. That's fairly rare. But they'll normally come to your local receiving facility under a BA 52 done by a mental health professional or law enforcement, or a BA1, an ex parte, completed by family or friends who just haven't had success any other way. They can go down to the court and do an affidavit. Okay. Within 72 hours after they're admitted to the receiving facility, the doctor has to determine, as you heard, whether or not they're going to pursue involuntary inpatient placement. They have to see them within 24 hours when they first come in, but they have 72 hours to make that decision. And this is one of those areas where when you speak with families who are very frustrated when they finally connect with you, their idea of the Baker Act is someone can only stay 72 hours, that's it. Because that's just always what is being told to them, but that's not really the reality. People can stay much longer. It's just the initial examination form is for 72 hours. Okay, so once the doctor determines that he wants to pursue the state hospital or he needs more time to treat the person, he would file a 32, get a second opinion. It goes to court, and the magistrate or a judge, depending upon the circumstance, the circuit, they determine whether or not they're going to provide a court order. And that order is called a BA8, and it's an order for involuntary inpatient placement. That order can be good for up to 6 months, as the judge said. And sometimes there's continuances done over and over, which is okay. But up until very recently, I had encouraged inpatient units to probably go to court if they have a sense about this person, and that they probably should go to court and get a court order as soon as they possibly can. And the reasoning for that was our wait time to get in the state hospitals were so excessive that there were times for South Florida State Hospital that it could be up to 3-4 months. I had a Pinellas County one where they waited 8 months for the person to get into the state hospital. So really, the sooner you get the court order, you get on the wait list to go to the state hospital. Central Florida processes all of our receiving facilities. We have 34 receiving facilities. They all send their packets, submit them through Central Florida Behavioral Health Network. We check them for accuracy and for content, and then we submit them to the state hospital, and then they are placed on the wait list. I think okay, for Florida State Hospital, it's circuit 6, 10, and 13, which South Florida, circuit 12 and 20. Okay. Okay, the receiving facility is notified that we've submitted the packet to the state hospital and that the person's placed on the wait list. That wait list has significantly gone down. It's probably 3 weeks for circuit 12 and circuit 20. A significant drop. I can't really explain why that is. They open up beds. Oftentimes what has happened with our beds is your forensic population spills into our civil bed population, and because it is a forensic 916 client, they have court orders that are criminal, so they get access to those beds quicker. Okay, just in terms of diversion efforts, once we get the court order, then the person is eligible for referral to a FACT team in their county. And they're also eligible for any residential programs that Central Florida funds. Now those are programs that they're not in Circuit 12, but they're all over the Suncoast region and Circuit 10. And they're able to be referred to those facilities if that is what the doctor and the team want to do. In some cases, they don't really want to pursue the diversion. They're, like Dr. Mario had said, they're a little hesitant to, if they got them this far that they need to go to the state hospital, they really want to follow through with that. But on the other side, as they're coming out, because we're going to continue to be involved with them, when they come out of the state hospital, they again could be referred to our residential programs and offered FACT services again. All right, let's see. If a case manager is not assigned to a person, if the person in the receiving facility doesn't have a FACT team or doesn't have a current case manager, they will be assigned a case manager. And that case manager is usually the person who's doing the transfer eval, which I'm not going to get into that. But if they do have a FACT team, then FACT will obviously stay with them. The department does allow, in their guidance document for FACT, the ability for FACT teams to close these cases that go to the state hospital after 3 months. But I don't do that. I'm not really a proponent for that, because then you just have to reopen them when they come back out. And that's a lot of paperwork and a lot of, the client doesn't really understand all the time what's happening. All right. Okay, in terms of voluntary admissions to the state treatment facilities, we've had a few of those, and it has been to South Florida State Hospital, and it did occur in Circuit 12, where they wanted to send somebody who was voluntary to the state hospital, and we urged them really not to do that. And they did, and the state hospital interviewed the person and said, we're not admitting them, and you can take them home now. And they had to bring them back, and then they had to basically start the involuntary inpatient process over. And it doesn't make sense, but it's the state hospital has the right to review the admission if it's a voluntary that's presenting, because you don't have that court order that is sending them into the state hospital. Okay, just keep it right there. One thing I do want to say about the state hospital, relative to the diagnoses for people going in, There's been changes in the Baker Act, and there's the definition of mental illness, and that's supposed to be part of why you're getting ordered to the state hospital. But if you also have a co-occurring substance abuse disorder, or if you have co-occurring developmental disability of sort, or if you have a TBI, traumatic brain injury, the doctor really needs to prove in that paperwork that those are not your primary reason why you're seeking the state hospital, that you're seeking the state hospital primarily for that mental illness. I've had DCF Tallahassee office use their counsel out of Tampa actually intervening a motion to vacate from a case because they felt the person was really just a TBI and they shouldn't be going to the state hospital. Let's see here. Okay, during the stay at the state hospital, years ago, case managers were required to go to the state hospital, but they're not required anymore to go to the state hospital. That was required under 65E15 was the case management rule, and that no longer exists. So they can visit them in the state hospital. If they do, it's up to the provider agency, and generally what they've done is they go to the state hospital. They just go every 3 months and they visit the client. Okay, the obligation for case management or FACT, whoever's involved with the client, is to participate. That's probably the primary thing that we're looking for, because they're in a treatment setting. The thing we're looking for is for them to participate in the discharge planning. Because ultimately, all these places, the person, has case management or they have FACT, and that person knows them pretty well, knows them in all these different arenas, and they go into an inpatient unit, and then they go into a state hospital, and they have them in an isolated setting. It's a 24/7 locked setting. It's very different than what the case manager and FACT team go through with the individual and understands what their needs are, whereas the inpatient units don't always. So we work hard with the state hospital to try to get them to understand what actually happens, even though the client is saying something about coming back into the community and, oh, it's going to be great, I'm going to go live with my sister again. Well, you might have the skinny on the sister and be able to explain, well, that's probably not a really good option. Okay. It is the community provider, case management or FACT, and the managing entity who has the primary responsibility to find discharge placements. I can get packets of information from the state hospital and make referrals to our residential programs, but I cannot refer, nor can our community case managers take packets from the state hospital and refer to ALFs or adult family care homes. That's a HIPAA violation, it's third-party information. So the state hospitals we can tell them where they need to send that information, and then they send that. It does sort of slow the process up a little bit, but that's what you have to do. Okay, there's something called the Seeking Placement List and Pre-Discharge Planning. All of these calls occur with the state hospital and the community provider who's involved with that client. Okay, just stay right there. The main focus by the department for a couple of years now, actually it's as a result of a second lawsuit after they'd gotten out of the Johnson lawsuit that lasted 25 years. In 2013, they were, Disability Rights of Florida sued them again, DCF, ACA, and the 3 civil facilities. And part of the settlement, they didn't negotiate a consent decree, they just settled the case. And what resulted in that was that there was additional funding, voucher dollars and such, that came into the mix so that we could have access to that to help facilitate discharges. The focus at that time was you had individuals who were placed on the seeking placement list, and they would remain on that seeking placement list. In this case, the girl was on there for 3 years. So certainly that's a little excessive. Now, if you're placed on the seeking placement list to come out of the state hospital, it is assumed that all of the facility barriers that have to be resolved. Example, they have to have had their benefits reapplied for, or they got a statement that they're going to be able to just reestablish them as soon as they come out. If they need a nursing home, a level of care has to be done already. They have to have an ID, a Florida ID, or Social Security card, or a birth certificate to secure that item. those are barriers that have to be resolved by the state facility before they can put them on the seeking placement list. Once they're on the seeking placement list, it now goes on the community, and the clock starts for the community. We have 30 days to place them. Not always successful in 30 days, because if you're referring to a residential program, you have wait lists, you have referrals, you have interviews that have to occur. And just trying to find general placement for people, it just doesn't go that fast. So sometimes we're effective at getting them out within 30 days, but more often is the case that we exceed 30 days trying to find placement for them. But we do have access to, as a result of the most recent lawsuit, there was introduction of SAM vouchers, and in certain areas, Circuit 6 and Circuit 13 has a special FACT voucher program, which would encourage people coming off of the FACT teams and being able to make room for the people coming out of the state hospital. Okay, I'm just going to touch on the forensic real quick, because I don't do forensics, but just for your information, there are 4 forensic state hospitals. Florida State Hospital, which is Chattahoochee, the other side is civil, this is the forensic. Then there's North Florida Evaluation and Treatment Center, South Florida Evaluation and Treatment Center, and Treasure Coast Treatment Center. Those last 3 are run by Correct Care, which again are privatized. It's a privatized company that's contracted with the department to administer those facilities. And I think that might be, oh, forensic, okay. I'm sorry. Okay, forensic are individuals committed under Florida Statute 916, and it's, they're determined mentally ill, but they've committed a felony. And they're either determined incompetent to proceed, and therefore they have to either go into the state hospital to receive treatment. Sometimes it's negotiated that they could actually come out and receive their competency training in the community, but often they end up going to a forensic treatment facility. The other individual who under 916 would be the NGI, the not guilty by reason of insanity, and they would be sent up to the state hospital for, I think it's a period of 5 years. And then after that, they would come out and they'd be on a conditional release order. The forensic system is pretty elaborate and very high pressured, because you have these these orders and you have to move. You don't have a lot of time to wait. We have had the benefit of additional funding for these forensic multidisciplinary teams, which sort of like a FACT team, but it's just focusing on forensic. Many, many years ago, when Central Florida first got the contract from the department, one of our teams was a forensic FACT team, and they served Pinellas and Hillsborough County. But what happened, and I don't know why they did this, but what happened was they kept those people on their caseload, but what happened was that they had already resolved their 916 involvement, and they were no longer 916, they were technically a civil individual. And I found that about 1/3 of them continued to be 916 clients, but 2/3 of them were civil. So, and at the same time that was going on, we found that you can't isolate or tell a client where they can be 916. So they could commit these felonies and find themselves incompetent to proceed or not guilty by reason of insanity anywhere, and they would be on a FACT team. So what I found was that all the FACT teams that we had forensic people on their FACT team. So each FACT team had to learn how to work the court system, how to respond to the forensic aspect of it. They don't have a lot of those, but they have enough. They have enough that they've had to become a little more familiar with that system. Yes?
Your decision to have the North Florida and the Treasure Coast be male only, is that law, or is that a policy that you made, and is that working?
Yeah, I didn't make that decision. That's these are state of Florida facilities, so that would have been made by DCF in Tallahassee as far as the facility management. They would determine.
Are they at capacity? I guess I'm wondering, are they?
They are generally, again, I'm not the forensic person, but as I understand, they're generally at capacity, as are a lot of our civil facilities. They're generally at capacity. So it's really moving one in and moving one out, and it doesn't depend upon the county. So, many, many moons ago when we had the other lawsuit, it was if you had Pinellas County, if you discharged a Pinellas County one, then you could admit a Pinellas County one. Now it's just if a bed opens, you can open it. Did you have a question?
I was going to ask about civil commitment for sex offenders post-conviction.
Mm-hmm.
Are they?
No, they are not. The civil commitment sex offenders, the ones that are housed in Arcadia?
I don't know where they're housed.
Okay. Yeah, that's a, right. I'm not involved with those. That's a civil commitment. It's a whole different, really, level. It's not a 916 and it's not a Baker Act. It's really just a step down, I believe, from prison. They've met, but they still need treatment and they still need to remain in a secure facility. Okay, I could just give you a few numbers as far as, okay. The admissions to the state hospital through January, there were 149 admissions. Now this is to the two state hospitals, Florida State and South Florida, because that's who we admit to. Of those, 34 or 23% were from Circuit 12. And you would have admitted directly into South Florida State Hospital. At the same time, and I can't give you specific for Circuit 12, but of the 149 admissions, going alongside that, we also had 49 diversions, which is good. So it's about a third, comparatively. The current census at the state hospitals for the civil beds in the 3 state facilities that we work with is 228 individuals are in the state hospital that are followed by the Suncoast region or Circuit 10 case management or FACT teams. Okay, as far as referrals, which is, there's a big difference between the people who are admitted and the referrals. We've had 183 referrals and we've had 149 admissions, and that's through the end of January. Circuit 12 has had 29 or 16% of those 183 referrals. I already talked to you about the wait list. Currently, as far as waiting for the state hospital, at the end of January, there were 2 people waiting. One private facility and one crisis unit, which is really, that goes up and down and probably is very different from what you hear at possibly meetings, because people get frustrated with this process and it's sort of a mystery surrounding how you get to the state hospital. I was at one acute care meeting in another circuit, and they said, well, you got to wait 6 months to get on the wait list to go to the state hospital. But they never had petitioned the court. And I said, well, no, you have to petition the court to get on the wait list. And once it turned on, they've like quadrupled, well, 100-fold their referrals to the state hospital. But they've also diverted people, so. But I did want to mention that the admission rate, compared to last year, our admissions are up significantly. We've had 149 admissions as of the end of January. As of the end of January last year, it was 102. So we are up significantly. Circuit 12 is up from, well, you have 34 now, you had 25 last year at this time. So there is an increase in the admissions. And I'm just going to say that people ask, well, why is that happening? And I have to say that I really think part of the difficulty is you have individuals being discharged from the state hospital sometimes quicker than what we would want. And so they come back out in the community and they're really not ready, and they'll end up back in a receiving facility sometime within hours, days. So, okay, any other questions? All right, well, thank you very much.
Good afternoon. I'm the bookend. You're an amazing audience. You're still here, you're still attentive, you're awake. And I think all the speakers have been phenomenal. And I've learned so much about what you're doing here that I just want to say how proud all of you should be of yourselves in this community, because it really is impressive. And if you think that this is going on everywhere around the state, it's not. And that's part of the reason that we see the kinds of wait lists at these state hospitals, because people are not doing what needs to be done to change that dynamic. In fact, What I wanted to start off by telling you this afternoon is that I believe that one of the reasons that we have not been able to build a comprehensive system of care is because so much of our money goes to what we call the competency restoration system, the forensic side. So the way it works, if you are charged with a felony in Florida, and it's different by each state, but if you're charged with a felony in Florida and you are incompetent to proceed, you are first, we try to get you restored to competency in the community, and if you are incapable of being restored in the community, we send you to a forensic facility for restoration. But what's happened is, and the court in some ways may be partially to blame, the forensic facility, it's not really a hospital, we call them hospitals, but they're not hospitals, they're competency restoration facilities. They get misused because what happens is the person comes in front of a really well-meaning judge and we really want to help this population, but there's nothing in the community for them. So we send them to the state competency restoration facility to get them help. But that's not what they really do at these facilities. In fact, if you want to see something really strange and funny, you can Google, you know who Samantha Bee is? She has this, she's a comedian. She actually did a piece on Florida's competency restoration system. And it's really worth watching. So you can Google Samantha Bee and Florida's competency restoration, and you're going to see how ridiculous our system is. So what happens is, if you are incompetent, we send you to these very nice facilities. They are very expensive. They cost between $65,000 and $75,000 a bed. And the first couple months, we try to get you stable. Incompetency is not a medical term, it is a legal term. And it means that you are unable to assist in your own defense and that you do not understand the nature and consequences of the charges against you. That is the legal definition of incompetency. So they go to these facilities. Some of them use a game show format. Most of them have a pretend court where they have a pretend judge and a pretend prosecutor and a pretend bailiff and a pretend defense attorney. And they try to teach the person how to assist in their own defense and understand the nature and consequences of their charge. Well, the system blew up in 2007. And that video that you saw was a result of what had happened. See, Florida ran out of competency restoration beds. And we are unique in a very good way that Florida requires that once you are adjudicated, meaning the court has found you incompetent to stand trial, the Department of Children and Families physically has 15 days to take the body from the jail to one of these facilities. And in 2007, they decided that they would ignore it because there had been an explosion of people going to the jail and being found incompetent. And why did that happen? Because what happened was Florida severely cut back the dollars for mental health in the community. And so people couldn't get access to treatment, so they ended up getting arrested, and they ended up having to go get restored. Well, we ran out of beds, and in what was one of the most fascinating lawsuits, the sheriff from Pinellas County teamed up with the public defender from Pinellas County, and they jointly filed a lawsuit against the state of Florida. Now, how's that for an odd bedfellow, right? Sheriff and public defender. And the case ended up in front of this wonderful, very tough ex-Marine, and he said to the state of Florida, you have two choices. You can either start to provide some treatment in the jail while people are waiting, or you need to get these people out. And the secretary was a wonderful woman at the, who was serving as secretary. Her hands were tied. So he found her in criminal contempt of court. She was fined $80,000, and she was given 60 days to fix it or she was going to go to jail. So what happened? The legislature had to meet in an emergency session, and they immediately allocated $68 million so that they could rent 300 beds to get rid of the backlog, because the guy in the video I showed you this morning who tragically jumped off that bed had been in jail 6 months when he should have only been there 15 days. And this was happening all over Florida. And so they got rid of the backlog, but they didn't do anything to get rid of the problem. And let me just give you an idea how bad the problem is in Florida. Florida currently spends 22% of its entire adult mental health budget. It's $144 million a year to restore competency for 2,500 to 3,000 people. While at the same time, we have between 150 and 160,000 people who at the time of their arrest in Florida need acute mental health care treatment. But because so much money is going to the restoration side, there's no money. And this is Florida, remember? And we know taxes is a 4-letter word. So what they have done is they take the money from the community system to fund the forensic system. Why? Forensic is an entitlement. It is constitutional because under the Fifth Amendment of the Constitution of the United States, we are all entitled to a fair trial. And in order to get a fair trial, you have to be competent. You have to understand the nature and charges against you, and you have to be able to assist in your own defense. And if you can't do that, you have to be restored. And so the system has fallen on its head. It is upside down. Now, maybe if those 2,500 to 3,000 people a year had been charged with committing really heinous offenses like murder and arson and all kinds of horrible things, then maybe it would be worth spending that kind of money to put those people in jail. But the story gets worse because we analyzed the system. And what did we find? We found that for 70% of the people that we're spending $144 million on a year, 3 things happen to them. Number 1 is you get credit for time you're at the hospital, okay? So for a third, they get credit time served, they come back to court, and they walk out of the courthouse without any access to treatment. Another third, the victim disappears, charges get dismissed, and they walk out of the courthouse without any access to treatment. And then the other third maybe get put on probation, and then they leave the courthouse without any access to treatment. Our forensic system in Florida is the definition of insanity, where you keep doing the same thing again and again and you expect a different outcome. And it doesn't make sense. And so what happens is there aren't enough civil beds. Why? Because the forensic beds, the criminal beds, are eating up the civil beds. It's ridiculous, the numbers right now. And we don't have enough both anyway. Now, we need restoration in Florida, but it should be only for the people that are really being charged with these heinous offenses that probably need to go to prison. And so there needs to be a grand smart plan. And part of the grand smart plan is what we've been talking about all day. How do we divert people so they don't end up in the criminal justice system to begin with, so we don't use up those beds unnecessarily? Now, nationally, there's about 60,000 competency evaluations ordered each year, and about 20% of those end up as being adjudicated incompetent. These hearings are very expensive, they are very time-consuming, and as I told you, the outcomes everywhere in the United States are horrible. The U.S. is spending $2 to $4 billion right now a year just on restoration. It's ridiculous. Now, competency is really an interesting principle. It actually goes back, we either think to Edward I in 14th century or in English common law in the 17th century. We found 2 articles that sort of lead back to this. And the way it worked is if someone committed a crime or was charged with committing a crime in England and they wouldn't talk in front of the judge, the court had to determine if they were malicious or it was a visitation of God, meaning they had a mental illness. And so what they would do is they would take the person and they would beat the living, I guess French has already been used, crap out of the person. And if they spoke, they were malicious and they would prosecute them. If they didn't speak, they were considered to have a serious mental illness and they would not prosecute them. But that's the same principle that we're using today. We just don't beat them up. But eventually, what we led to was this due process, and that if you were in fact charged, you needed to be able to be competent to stand trial. Now, that sort of made sense 50 years ago, because 50 years ago, there were very few people in jail in the United States with serious mental illnesses. In fact, in 1955, there were 560,000 people in state hospitals around the United States. There were about 5,000 people in jails and prisons with serious mental illnesses. So when you're trying to restore about 5,000 people a year nationally, not so bad. But what happened? We closed the hospitals, we went to sentencing guidelines, we cut back mental health services, and it's a fascinating number. So if the United States continued to have state hospitals at that level, and I'm not advocating it, it wasn't necessary, but I just want to put this in some context for you. If state hospitals continue to grow at that pace, and the American population grew as it did, right now you'd have 1.5 million people in state hospitals, civil hospital beds around the United States. Right now, in reality, we have about 32,000 beds in the United States. But last year, we had 1.5 million people and 2 million incidents with serious and mental illnesses arrested. So think about it. We've trans-institutionalized the problem. We took people from those really horrible, crappy hospitals that many needed to be closed. We did not provide them with the level of services that they needed. They went right past us, and they went into the criminal justice system. And in many ways, we made it worse, because now not only do you have to deal with the stigma of having a serious mental illness, now you have the stigma of being a criminal with serious mental illness. So what does that do? It makes it harder to get employment. It makes it harder to get housing. You start hanging around criminals and learning criminal behavior. So we have really messed this thing up royally. And that's why what you're doing today is so incredibly important, because it can be fixed. It wasn't always this way, and it can be fixed. Treatments are better. We're smarter. We've got good doctors. There are ways to fix this. So how do we do all this? And what should it look like? I told you that it has to start in each community, stepping up, and that's what you're doing today. And so we need this systematic change. It's not about fixing the competency system. It's about fixing the community system so people don't end up in the competency system. I believe, and Florida is getting there, they are agreeing with us, that we need to limit competency to the most severe people, dangerous people, okay? And one of the things that we have done in Miami through a pilot program that has been enormously successful is we looked at this population. And the reason I know so much about this is after the secretary was found in criminal contempt of court, I got this very strange phone call from someone who said he was the Chief Justice of the Florida Supreme Court, and he was. And he asked me to come up to Tallahassee to talk to him. Now, the judges here will tell you that when you get calls like that, you think you did something really bad. So I went up to find out what I had done wrong. And the Chief Justice, Lewis at the time, wonderful guy, said, look, it's great that we just found the Secretary of Criminal Contempt of Court, but the legislature will never give us another dollar if we keep doing this. And we need to fix this problem. He says, I want you to fix it. So we started to study it, and we started to look at better ways to do it. And what we realized is that at least half the people we were sending to competency restoration really didn't need to go. And so we looked at a better way to do it. And we said, you know, why are we just focused on restoring them if they're not going to get any time or get treatment? Most of these folks are going to get reintegrated back into the community. So let's set up a system that takes people who met criteria to go to restoration, but don't need it because they're going back to the community anyway, and let's focus on reintegrating them back into the community. So we got some money from the legislature, only $1.7 million, which is nothing compared to the $144 that they're currently spending. And we took people who definitely would have gone to the restoration system. We kept them local. They're in a locked program at Jackson Memorial Hospital. And what had ended up happening? They stayed half the time they would go to a forensic facility. They got great treatment. It was half the cost. And then once they were stable, We put them in our felony diversion program, monitor them for another year, and our outcomes are phenomenal. Almost zero recidivism. They get to stay with the same provider for life if they want to do it. They're using injectables, long-term injectables. They love it. They prefer it. And it's really worked out very well. So last two sessions ago, the legislature did a study on what we've done. They're like, wow, this really works. Yeah, treatment works, duh. And and they expanded it. Now, they have authorized 4 sites, one in West Florida, North Florida, Central Florida, and Broward. And interestingly enough, and just to give you an idea how Florida really is 67 counties that work independently, unfortunately, sometimes. Just across the border in Broward, which is half the size of Dade, they send twice as many people to competency restoration as we do. And it's because they have different systems in place. And it's hard to make these kind of changes sometimes. So we have them authorized. You need to be advocating to your local legislators to fund those 4 other sites so you can start to take people out of the competency system, because you know what that's going to do for you? It's going to open up more civil beds. Now, what happens is the reason we have problems on the civil side is 2 things, and I'll get to this in a minute. A is we are a minority state. Now, you're like, what does that mean? Most states have a standard that makes it easier to involuntarily hospitalize people than Florida. Each state makes its own standard. It's not a federal standard. We're one of like 4 states now that make it almost impossible to get into the hospital. You heard the case law, it's difficult, and they should. People's rights are at stake. However, Florida doesn't do this because they're great civil libertarians. They do it because they're cheap. And if you have a high standard, you don't have to pay for someone's treatment. You don't meet criteria, hey, you're not sick, you don't need help. So we're not paying. So one of the, getting ahead of myself, and I'll come back to this, but one of the things that we really need to start looking at is what should our standard look like? And the first thing we need to do is fix the competency side so we can open more civil beds. Then the second thing we need to do is look at what our standard is. Now, it's fascinating, the standard for involuntary hospitalization in the United States. Does anybody know where it comes from? Dangerousness to self or others? It comes from like 15th, 14th century England. And, there's all kinds of fascinating case law that you can go back and read. The common law was fascinating. They wrote all this good stuff up. And, it was people that they were worried about that were possibly hurting other people or hurting themselves. We're using the same standard from back then. And just in the last 10 to 20 years, we now know that the longer somebody goes who's in a psychotic episode without treatment, that the longer possibility there is for permanent brain damage. And it's terrible. We're letting people get sick. We're letting them get sick worse, and we're making it really difficult for them to recover by waiting so long. So we probably should start to think about how do we add a need for treatment standard on top of dangerousness to self or others. We shouldn't really wait. Now, I say this, and you're going to say I'm contradicting myself, but it really needs to be nuanced, because I am a firm believer that you can't force everybody to get treatment, nor should you. And if you can work with the patient, the client, to be part of their own treatment first, it's better. You get better results, they're happier, they work with the doctor better. So while I think we need to expand that standard, it really needs to be used in a last resort. Okay? And we really should do everything in our power. There's all kinds of new training. There's Dr. Amador. Many of you may have read his book. He's phenomenal. He's going to be in Miami with me in a couple weeks. And he's got a new training program called LEAP, and it teaches providers and counselors how to encourage people to develop this trust to get people to take their medication without having to force it. And if you can do that first, that's what we should all do. We shouldn't be lazy. And Judge Quartermain said something earlier today that struck me as really interesting and correct. People that don't have mental illness or it's not in their family are pretty naive and silly and stupid about this. We think, the civilian types, that if we just give people their medication, they're going to be fine. It does not work that way. All the medication does is reduce the symptoms. It cures nothing. And there are some really tough side effects on these medications. And they make people feel kind of weird sometimes, so they don't want to take it. And so we have to be thoughtful about it. And so we have to provide these other therapeutic responses as part of it. I've probably learned more from my peers than anybody else. I told you I have 8 peers that work for me. 3 or 4 of them graduated from my program. They were arrested. And one of them said something so poignant to me. He said, you know, Judge, when I got medicated, my symptoms were reduced, but I was still hearing voices even when I was working for you. He said it wasn't until I went to trauma therapy that I got to move forward. And once that happened, we lowered his medication. He's amazing. He's been working for us 10, 12 years now. He's now married. He's schizophrenic, okay? But we got him when he was really young, and we got him treated really quick. He's married, has a kid, owns a house. He's a taxpayer. He's one of the best employees I have. He has a life. So, what should a system look for? We talked about the sequential intercept model, which we did in Miami, and that's how we started 18 years ago. But I believe there should be a 0, not at 1. 1 starts after you have had contact with law enforcement. Why are we waiting that long? Most symptoms for serious mental illness begin in late teens, early 20s. There is a cluster of genes, and they are on this line. And on that line is everything from ADHD to autism to schizophrenia to bipolar and major depression. Okay? And these things start to manifest themselves at an earlier age. And we also know that trauma, as I described earlier, is one of the leading causes of serious mental illness, particularly that lead to substance abuse and pushing people into the criminal justice system. So sequential 0, in my opinion, should be 2 things. One is every school in the United States, in middle and high school, should be screening for trauma. It's very easy to do, okay? We're not looking to medicate the whole world or anything like that. But you know what? My kid's in public school. He couldn't start first grade without a letter from the doctor that he had been examined. I mean, the head's connected to the body. And so the school should be screening for trauma, but so should pediatricians. And we're really starting to have some nice dialogue with the medical community, and we should really be moving that way. So number 1 is you want a 0. You want to work with your school system and your local pediatricians to start to do that. And your preschool programs. I'm for that. All right. 2, we must have, and Florida's pretty good on this because we use Medicaid dollars to do it, you have to have immediate available crisis care. I go to some states, they have none. I mean, we don't have good long-term, but we have good crisis care here. And you know, when someone's in psychosis, you know, it's very serious. And we shouldn't wait long. They need to get there immediately, and they need to get treated immediately. You know, these are like heart attacks of the brain. And, you know, God forbid you had a heart attack. Should you be on a wait list somewhere waiting to get treated? Damage is going on in that brain. It should be immediate, and it should be quick. 3rd, we need good diagnosis and treatment. And that sounds a lot easier than it is. And the doctor will tell you this is really hard stuff. There's not a blood test or an MRI yet for many of these illnesses, although we're getting close. I mean, there's some really great work being done at UCLA. They can really see schizophrenia now on certain types of imaging. And once I think we get to that, it'll be really hard for the insurance companies to turn you down. because then it's real, okay? And so we have to get there, and we have to continue to push that. But there's a shortage of psychiatrists, terrible shortage of psychiatrists. And there's even a bigger shortage of really good psychiatrists. So you're lucky you have one in your community. But it is very important. And the treatments that they have to do, and it was mentioned, and for our population, you're right, it's about 75 to 80% of everybody that gets arrested with a serious mental illness or goes into the public mental health system has a co-occurring disorder, mental health and substance use. Now, this is the other part that drives me a little batty. So one of the other pieces I'm going to talk about that you really need in a good system is a good technology system. And when we started to put our technology together, we got this amazing opportunity through a pharmaceutical company. They invested $80 million to see if we could eliminate all the fragmentation in our community mental health system. So the first thing that we did is we started meeting with the medical directors of all 38 providers in Monroe County. What did we find? It's stunning. I don't understand how the profession allows this. All 38 providers were using 38 different assessment tools. They were getting 38 different diagnoses. They were putting people on 38 different medications and 38 different case managers. And you wonder why this stuff doesn't work. And for 30% of the people that are in the public system, in a large urban area like mine, they go to multiple providers sometimes in days. And they didn't talk to each other. And they didn't even know that they had been at another provider a week earlier. So it took us 2 years. But we came up with a common assessment tool for all the providers in town. It's one of those weird things to talk about, but have a huge impact. So that needs to be fixed. We need medical homes. He shouldn't be an orphan. Dr. Oliva should be in a medical facility with primary health care doctors. Look, a lot of these illnesses are comorbid. We know that diabetes causes depression, not necessarily the other way around. And so when people go for a physical exam, they should have a psychological exam, and it should be in one place. And I think that would reduce stigma significantly because they would be getting both at the same time, and people wouldn't think, oh, he's going to a psychiatrist. You know, it would really help, and we would get much better care, and they could talk to each other. We need to have this relationship with the criminal justice system. You need a pre- and post-arrest diversion program for every single community. Your law enforcement have to be trained in CIT, and the court systems have to have diversion programs to better identify people once they get arrested and get them out when they can as quickly as they can. You need a competency alternative forensic system like I talked about, like we call it MD-FAC, Miami-Dade Forensic Alternative Center. We need a good intensive case management system. You have FAC team, but how many are you allowed on your FAC team? 100? Okay, and how many probably really qualify for it in Sarasota? 500? 300? At least, okay? So you have to have a better intensive case management system. We pay case managers terrible money. They get burned out so quick, they leave immediately. And so it's hard to get good treatment if your case manager is gone every 3 months. So we need to think about that and come up with a better system of care. And in large urban area, we're even looking at how do we centralize the case management so that we make sure that one person, one case manager. We need to look at new approaches, and there are some that are really interesting. One is called open dialogue. If you haven't heard about it or learned about it, you can Google it. It came out of Finland. And what it is, it's a first episode approach, although I am starting to think it doesn't need to be just for first episode. But what they do in first episode, I may take a little judicial, I just need 2 minutes, I'm almost done. She can't overrule me, so where did she go? All right, so open dialogue is fascinating. Somebody has a first psychotic break. They call 911. They don't send the police, which they would probably prefer. Okay? They send a team to the house. And they have a family counselor that takes the parents in one room. They have a therapist that takes the person that's having the break. They talk to the family not to freak out. They assess, see if they can leave the person there. They don't escalate the situation. They don't handcuff them to go get them treatment. They try to talk them into some treatment and medication at the home, and they've had amazing results. They're testing it in Boston and Atlanta and in New York a little bit right now. It's something for us to keep an eye on because I think it has a lot of potential. Assisted outpatient treatment, which we're going to talk a little bit more. We were able to expand it. If you don't know what assisted outpatient treatment is, that is a new law. Well, it's been on the books a long time. It's a rarely used law, and then we expanded it to county court judges in the criminal division. And it's for people that meet a certain criteria that are refusing medication. And it's kind of that nuanced I was talking to you about for people that don't have insight to their illness and won't work in the existing system of care or diversion, where you can order them to be treated, and if they refuse, they can be hospitalized as opposed to jailing them. And it's just starting to bloom here in Florida through the county courts, and in a couple years we should have some decent data. But again, I think it's something to consider. I heard the police talk about their homeless outreach program. Fabulous. We have the same thing, but we found a little bit of a problem. We weren't getting the results we wanted. And we still had a pretty good urban homeless population that was very sick. So we started something called the Lazarus Project, where we send a psychiatrist out to the street, and we're treating people on the street. It's wonderful. And it's like, homeless outreach 2.0. And what you find, it's not that people don't want to be housed, but when you're schizophrenic and you have a lot of stimulation, you don't want to be in housing with a lot of loud people. It makes you worse, and they're miserable. So they want to be on the street at that point. So what we try to do now is treat them on the street, reduce the symptoms, and then try to encourage them to come in. Trauma services, not just being trauma informed, but trauma treatment. And if you don't have good trauma treatment, you should talk to your local VA. They have great trauma treatment because of all these kids coming back from Iran and Afghanistan with serious trauma, and they could help train your trainers to do some trauma work. You need meaningful day activities. This is the greatest example of what I'm talking about. Vincent Academy, okay? This should be in every community in the United States, and God bless you all for doing this. And it's not just I'm saying this because it looks beautiful, but there's actual, real research now that Dr. Kendall, I don't know if you know who he is, he's a neurologist. He won the Nobel Peace Prize for Science, and he has proof that shows that when you do something that you like to do, you do something that you love, okay, it actually stimulates your neurons and it helps in your recovery. I did a wonderful interview with a couple of the members a little while ago, and and they were telling me their stories and how much they're loving this and how this is helping them get their lives back, and they have hope again. Hope helps you heal. It's not that it's just a good thing. And think about the reverse what happens. You reach retirement age. You've had a great job. You've had a great career, and it stops. People get depressed. Why? Because they're getting less blood flow to the neurons. It's the opposite that's happening. So we have to continue to help people have good, meaningful day activities. It's critical for recovery. You need supportive housing. You need supportive employment. Peers are critical to this process. They are the best. They are the secret sauce in our project in Miami that really have helped it. Why? Because when people get arrested, by the time they get arrested with a serious mental illness, we have found that they have clinical depression on top of their serious mental illness. They have given up on life. And it's not always that they don't have insight to their illness. They don't give a damn. And once you've reached that point, giving them medication is meaningless. And so what my peers do, and they've burned every bridge, they've pissed off their families to no end at that point, they've used a lot of money, everyone's angry at each other, they have no one to talk to. And there's also all this good neuroscience that shows one of the main functions of a human brain is to develop relationships with other humans. It makes us feel better. And so the peers help reestablish those relationships. So you have to get your peers, you get them certified. It helps them in their own recovery, and they help other people in recovery. SOAR. You have to, since we're in this great state that doesn't have expanded Medicaid, because we really like taking our tax dollars of $52 billion and giving it to other states. Okay? So We have a program called SOAR. It's a national program, and it helps expedite federal benefits. And it's critically important because when people are ready to leave the jail or any of these systems, they have to have their benefits in place so that they can pay for their services. We cannot be naive either. And Mark kind of touched upon this. There are clinical and criminogenic risk factors to some of this population. Even if they didn't have a mental illness, they would be at risk of arrest. Substance abuse, living in zip codes with high crime rates, literacy. So what we do in Miami is once you're qualified to come into the program, we do 3 screenings. We do a psychosocial evaluation to make sure to see what your mental health issue is. We do a Texas Christian University drug screening profile to see how bad your substance use issue is and what it is. And then we use something called ORAS, Ohio Risk Assessment System. Write it down, ORAS. And it's great because A, it's validated, and it's even greater because it's free and it's in the public domain so you can use it. And what that does is it looks at trauma and criminogenic risk factors. And so for some of this population, just giving them mental health treatment may not be enough. They may need cognitive behavioral therapies to deal with some of their criminogenic risk factors. So that's how you're going to get better outcomes. I'm almost done. We need to start looking at advanced technology on how we can monitor and work with this population. We need to reform our involuntary hospitalization laws, as I already mentioned. And we need to start to convince policymakers to fund services that work. Medicaid is wonderful, but I don't know if you're able to pay for some of the services here at Vincent Academy. And you should be able to. In some states, even non-Medicaid states, you can use Medicaid for peers, for clubhouses, for Fresh Start programs, and it's really important. That is as important as medication for most of this population. Give them their life, and it would be a lot cheaper for the government to help them get jobs and stuff by helping them get to that level. And finally, we need to dedicate resources to this illness just like we do others. We should be hammering the insurance companies. They know I'm after them right now. They're coming to talk to me, okay? But we're letting them off the hook. And they're pushing people into the public, under-resourced system. It has to stop. And so with that, I just want to say, look, not one person, not one party, not one institution created any of this issue. It actually probably happened from some of the best well-meaning people in the world. But it's going to take not one party, not one institution, not one individual to fix it. It takes an organization like this that you are doing here to fix it, and it can be fixed. So don't give up. Keep fighting. We've got your back, and we want to work with you. Yes, sir. Although that's in Florida, some states have it. And you should find out which states, and I'm telling you, they're not even expanded states, but you can look at the codes that they have and see how they're able to bill Medicaid. I don't disagree. We actually proposed in 1115I. We've done a couple proposals to the legislature to help them stretch that out. It's fallen on deaf ears to this point, but I'm going to try again next session. We need to do that. It is a very important thing to do. I chair the Florida Supreme Court's Task Force on Mental Health and Substance Use. We have a bunch of legislative proposals. We got a bunch done 2 years ago. We have a new speaker and a new Senate president coming in. The Senate president's not too far from here. He's in the Tampa area. He's terrific. And the incoming speaker's from Miami. That's why I've been waiting. Yes, and that's not good. I agree. And look, I will give you my bias. I chair my ME. But it would be much more efficient to combine the Medicaid dollars and the public dollars in the MEs. They have no overhead. They're much more efficient. It's politics. The HMOs, they have a lot of money and they have a lot of influence with the legislature. But it is probably something that should be done. We would get better outcomes. We would spend the dollars much more efficiently, and we would probably double the amount of money we had. I agree with you. Yeah.
So we're going to start the conversation with incentives in the Baker Act, because that's where we started with this topic. It's the Baker Act. So I'm going to start with Dr. Oliva, okay? At any, we heard from Ms. Carter that the wait list is down, and that's a wonderful thing. But I recall a couple cases where we did have a wait, and it wasn't that long ago, and imagine that it is cyclical. So, what is your experience in terms of the length of wait since you've been there?
Like they say, it's very cyclical. I've had as many as 8 people waiting for the state hospital, ranging from 2 weeks to up to a couple of 3 months. Right now I have no one.
Okay. So now let's talk about where those patients fall in terms of income to Coastal. So when they are in that waiting period, whose financial responsibility are they?
I'm not completely sure. We're
I
not
think-
for profit, so I don't know. But
They're yours.
Yeah, they're Coastals.
Maybe Central Florida.
And that's part of the problem.
Unless
Okay.
they're billing Medicaid.
So what often happens is the doctors, and I'm not saying Dr. Oliva, I see this in my community, they are reluctant, if it's a close call, to move to involuntarily hospitalize someone for 2 reasons. One is we're big and there's one place for the hearing, so the doctor has to go and wait all day for the hearing and they don't get paid. And 2, if the court finds that they meet criteria and there's no bed, which there often is not, they are stuck waiting in that crisis unit and could be months until a bed opens, and they do not get reimbursed for that time. And so there is a financial disincentive to the crisis units not to do this. And again, there's no blood test or MRI, so there's a little bit of discretion. And what they generally try to do is to get the person to agree to take treatment so they don't meet criteria anymore. And look, people are sick, they're not stupid. And so if they take a pill, they know they may be able to go home the next day. And it happens.
So did you have anything to add, Ms.
if I
Carter?
might, I think
Oh.
that might be a little bit more accurate for the privately funded hospitals, I would assume.
No, it's our public CSUs.
Your public CSUs?
Oh, yeah.
I know that our patients do remain DCF funded through Central Florida
And we'll
Behavioral
continue to
while
pay when
awaiting.
you're on the wait list.
Okay. So now let's move to once they're in state hospital, because you and I had a conversation about that, and I was sort of surprised. I assumed once an order from our magistrate was in place that a person met criteria, that the individual would stay, because there would be a 6-month review, okay? And it came to me through you. Well, listen, no, that doesn't mean he's going to be here 6 months. So what is? I mean, this person could have been discharged within a couple days, notwithstanding this big hearing that had happened and these findings that had taken place. So can you tell us a little bit about how that works and what the decision making is once the individual is at state hospital?
Well, once they get into the state hospital, most of them go into a civil admission unit. And really the objective of the civil admission unit is to try to discharge them as soon as possible, try to find something with the Baker Act to return them back to the community. If they endure their stay in the civil admission unit, then they get to the civil transition unit. The decision to make somebody discharge ready, it is supposed to include the community, and the community is always told that they're involved, but we don't really make that decision. It is the treatment team at the state hospital that determines that someone is discharge ready or placed on the seeking placement list, and then the ball's handed to us. I was going to tell you that the average length of stay now reported among the 4 civil hospitals, we only use 3 of them, is just under a year to 2.5 years. That's the average length of stay. But that's an average. We do have people who are, of our 228 people, who have been there. Some of them have been there well over 5 years. Some have been there 10 years, very few. Most of the people that we send to the state hospital, they could stay anywhere from 3 weeks to maybe 3 or 4 months. But you see these quicker turnarounds of individuals, and that is decided by the doctor on the unit. And it's pretty routine for them to say, they're not mentally ill, they have a substance abuse problem, they have an access to, they shouldn't be here, we can't treat an access to a borderline personality disorder. These are the things that we're told, and that presents a challenge because those people do end up back in the community and start all over again.
All right, so, and that's a good point. So I'm going to turn to Magistrate Wilson and back to Dr. Oliva. You know, when you see these individuals, how often are they recently released from the state hospital, and would you necessarily have that information once you have the patient? So,
I would say not often have they been recently released from a state mental health facility, but I see the dockets whenever, I get it once a week, I get it the day before. I will go through my court docket. One reason why I do that is to see if I know anyone on the docket. I grew up here in Sarasota. There's a possibility someone may be appearing before me who I personally know. Then we'd have to get some coverage for that. But the other reason is I will often recognize names, people who have been before me before. I would say maybe 10 to 15% of the time it's somebody who's been before me before, and I recognize that name.
Okay.
So,
and how about you?
Yeah, I would have to concur, all things considered. I by no means think it's a revolving door sort of situation, which is excellent for the most part. We have a couple of patients who end up going to the state hospital and staying a very brief period of time because perhaps by the state hospital's estimation, it's not entirely primary psychiatric issues. It might be more behavioral, although that wasn't necessarily my estimation, obviously, because we had them sent to the state hospital, and it's not a behavioral treatment unit per se. But I think that's the rare occurrence when it's
Okay.
looking more like that.
All right, that's good,
Can
because
I
I know.
just, can I just
yeah.
say one thing? The individuals that we get discharged out of the state hospital, we often get a leave of absence on them. We could get up to 30 days coming out of at least Florida State Hospital. And we ask for that because of the very real issue of once they come out, it often falls apart within days to a couple of weeks. So then we can simply take them to the closest receiving, the CSU, and Florida State comes and picks them up. And also, just one other thing, as far as the recidivism, the facility, the department's facilities, state hospitals, their performance outcome measure is within 60 days returning to the state hospital. Well, you can't get back into the state hospital within 60 days. So it's always good. It's always 0. They excel.
So going back to the incentives, and sometimes there are these quick turnarounds, and I'm hearing sometimes there are maybe decisions that others may not agree with at the state hospital in terms of how quickly they would be released. And I'm also hearing that they're full. I think that's what you said, the not the forensic beds, you called them the civil beds. So what's in it? I mean, what is at play with the physicians that are making these decisions, and how can we potentially improve that?
At the state hospital? Oh, well, I think the more understanding that they have, they have quarterly stakeholder meetings. It would behoove people to go up there and voice this, because these are things that they don't always realize. I had been up at a stakeholders meeting at Florida State, and afterwards got to go with Shirley Pace to tour some of her unit, and met with the doctor and the ARNP, and we got talking because we get into arguments a lot about these people. And I said, well, but you don't understand. You're taking them from the state hospital and you want them to go into an ALF, or we're referring them to our residential level 2. And they think that we have nursing and round-the-clock staff and that it's locked. And I said, no, that doesn't exist. And I think it's just an absence of an understanding of what does exist in the community, and that's partly what contributes to, they think that we're just trying to block things, and no, it's like, no, for safety reasons, this is where they really need to stay right now.
And the state has made it more difficult. So last year, they significantly increased the amount of money they would pay ALFs for seniors. And so what happened? The ALF stopped taking people with mental illnesses because they didn't increase them. And so they are now, the seniors are pushing out, so the business model for the ALFs has changed. And so we need to advocate to the legislature to raise the money the same they have for the seniors. And it is a real problem. And for the first time, we're having Miami is very blessed. We have a dedicated tax for homelessness. Up until recently, we were the only county in the U.S. LA just joined us. And there's a penny sale tax on every restaurant outside of Miami Beach that makes more than $400,000. But we raise about $58 million in taxes. It's amazing. And we reduced our homeless population from 8,000 to 1,000. And the 1,000 that are left, they're mostly people with serious mental illness and substance abuse. And so it's really important that when people are leaving the jail that there is a bed, or when they're coming back from the hospital, there is a bed. And it's something that we really need to continue to work on.
Yes, agreed. Now this is to Magistrate Wilson and Judge Leifman. I mean, if we were to improve the standard from this 1,500 standard, what would it be?
For me, what I'd like to see, and we're going to have capacity to do it, but it's a chicken and egg thing, so I think you should just do it and force them to come up with capacity later. I think you need to add some type of need for treatment standard. And again, it needs to be last resort. I would be doing everything else first. I don't think you should rush to force medication unless the person is really in bad straits and there is real imminent dangerousness. But after the other things fail, I would have a need for treatment, and I wouldn't let people go too long in psychosis without treatment.
I think I can honestly say I've never been involved with a Baker Act hearing where I didn't believe the person needed treatment. So I think that would be 100% commitment at the end of the hearing. But the standard in the statute now about dangerousness and having that the only criteria, that's, it's a difficult thing. They're trying to balance personal freedom against or with safety, and that's a tough one. It just is. But with this treatment standard that the judge is mentioning, that would result, in my mind, in a lot more commitment orders, whether the person's being committed for placement locally for 2 or 3 weeks or going to a state mental health facility. It would increase all that.
It would increase, but I just don't think there's anything civil or right about letting a man live under a garbage dump thinking that a Martian is talking to him or the CIA is out to get him. That to me is, you have to balance that as well with the civil right. But I also don't believe most people that we see don't need the long-term hospitalization. And maybe what we need to do is to reverse what we do under the Baker Act and have people in 2 weeks stay. Because in our diversion program, we divert people, and because they're on a criminal hold, the Baker Act doesn't apply. So we actually reset all of our cases in 14 days. And in most cases, in 14 days, it really is enough time for the person to stabilize. Mm-hmm. And at that point, I think we should think about then having the doctor initiate the hearing if they still need it, instead of the 72 hours. I think in the long term it would be cheaper. You would have less cases, and people would really have an opportunity to get where they need to be, and then we bring all these supports and services into them. I just think we do it a little backwards at this point.
And maybe that
I can't
begs
argue with that.
the question of assisted outpatient treatment, which is perhaps where a standard like that could be implemented, not necessarily inpatient lockdown treatment. But I know that's not something we have as a community use, and Dr. Oliva and I have talked about that, and it's, I think maybe you can comment on the challenges of using that process.
Right, yeah. You're talking about court-ordered outpatient treatment,
Yes.
right? Yeah.
Mm-hmm.
It's where you get a court order you have to seek treatment. The judge says so. The issue being it takes a lot of background work to get that done, and coming up with individuals that are actually going to put the time and effort into filling out these long, drawn-out treatment plans. They're good and they're helpful, don't get me wrong, but it's a major effort. And then you have to convince the doctor to go to court, like the judge said. it takes up a lot of extra time, but it would be quite helpful for the patient. I just don't know that we have all of the sort of necessary background ancillary resources in place to make it as effective as it should be if we were to actually implement it, if that makes sense.
Yeah, and what are the things that would need to be in place, either Ms.
For
Carter or
AOT?
Judge Leifman, yeah. in
Well,
our
the law
community?
requires that there be a guardian in place, and it has a specific standard. And we expanded it to county court criminal division because, believe it or not, we find that the defendants with serious mental illnesses are much more complicated and difficult, the ones that are charged with misdemeanors, because they've been homeless the longest, they have a lot of quality of life offenses, they are more resistant to wanting to take treatment. And the AOT has a standard by which you can order treatment, but a guardian, again, has to be appointed to do it. And we're about to start ours, so I can't tell you how great it's going to be yet, but I'm optimistic. And again, it's for what we call the 20%, because for about 80% of the people that come into our system on the misdemeanors, we've been able to help significantly. But for the 20 that are really incompetent, refusing, really lack insight, we need the AOT to do it. You know, one of my mentors, Hank Stedman, said there's no such thing as a treatment-resistant person. There's only treatment-resistant programs. And it's incumbent upon us to just keep looking for better ways to treat people that we are going to get what we need for them at the end of the day. And so I think we have to just keep looking.
Well, and I would just say that one of the reasons we have had success with that difficult population in specialized courts is because we have this hammer of jail, right?
Unless they're incompetent
unless
on
they're
this team.
incom-
Right,
well-
and these are the ones that we're having problems
Well,
with.
so I've had some different ideas about that, but I think that because it's the state attorney's job, right, to be the representation for the
Baker
crisis
Act.
stabilization unit, who is the petitioner,
Right.
then it would be incumbent upon that office to follow through with and it's not a prosecution, but it's this person has violated, let's bring them to court. And it's a form of a specialty court, which would be a whole nother role for a strapped entity to take on. And what are your thoughts about that?
Well, the only problem where we get stuck is if they're incompetent. I can't put someone in jail that's incompetent because they can't plead. They don't understand what's going on, and we're stuck. And again, the incompetency standard's a legal one. It's not a medical one. So they may be incompetent to stand trial on their criminal charges, but they're not necessarily meeting involuntary hospitalization under the Baker Act. And that's the narrow group that I think we should use AOT on. And that's what we're going after with the new law change.
All right. So I'm going to give each person an opportunity to make, a concluding remark, 1 or 2 sentences. 'Cause we are going to end on time. So I'll start with Dr. Oliva.
Well, like everybody has said, very thankful and grateful to have all of these individuals who seem to really be invested in making some positive strides. It's a lot of effort, and as long as we're all willing to really put in that effort and keep with it, persistence and patience are key, and we keep moving on.
All right.
And I have to retract something I said before. I am now afraid of Judge Quartermain with all these rules, but what I'd like to say is, and I guess this is like a commercial for the 12th Judicial Circuit. You saw our judges up here this morning talking about the specialty courts. They really, really are important. Justice has come a long way in how we view and regard the people who just cross paths with the court. It's changed a lot over the years, and I also know Judge Leifman doesn't like this with all due respect comment, but with all due respect, I think the 12th Judicial Circuit is the best in the state, and we're working very hard to help vulnerable populations.
Well, this is a great seat to be in here, between the two of you. I think this is marvelous to bring all these people together and educate people on the system at large. So I've enjoyed that, and to get to know you.
Thank you.
And I'm not scared.
So I just want to leave you with this last thought. Florida has about 100,000 people in prison. And over the last 10 years, the growth of the prison population in Florida has generally leveled out after years of going like this, except for its mental health population. So at the same time, we've seen a leveling out of the general non-mental health prison population. The mental health population with moderate to severe mental illness has increased by 153%. It's going up so fast that if we don't begin to do more of these diversion programs, Florida is going to need to build 10 new prisons over the next 10 years just for its mental health population. The cost to build and operate 10 prisons in 10 years in Florida is $2.2 billion. Most of these individuals are not committing serious offenses. The average stay for a person in Florida's prison with a serious mental illness is only 2.5 to 4 years. It's points. They're just have accumulated points. So there is something wrong with a society that's willing to spend more money to incarcerate people that are ill than to treat them. With those $2 billion, we could revamp this entire system and make it healthy. Thank you.
All right. And I just want to thank, again, the Vincent Academy. This, to me, is a very memorable day to have everyone here. I think it was a fabulous environment. Thanks to everyone who has been here. And I am torn because I really want to show you the next video. So I'm going to put it on. If you need to leave, I totally understand. But the reason I am torn is because today we learned that the individual in this video is now reunited with her son for the first time in years. And she is one of our success stories. So again, it's a couple minutes. If you need to leave, thank you for being here and have a wonderful evening.
Life for me before entering into mental health care court was hell. I lived on the streets in a truck. I couldn't stay clean. I was in an abusive relationship, and I would come to mental health care court to drop, and I would pee dirty, and thankfully I never got sanctioned. But I just kept living that way. I was broken and beat up and bruised and just an empty soul of a person. And one day when I had to go to court, the judge asked me if I was basically done, if I was tired of being tired. And I said, absolutely. I needed that big change. Change is scary, but it helped me to start defining who I was, being in the domestic shelter and having to do the mental health care court, because doing the mental health care court was like having a job. I had to be there 3-4 times a week. I had to drop every day. I had to go to groups, which I'm so grateful for. It was hard. It was really, really hard at first to become adjusted to the program. But after a while, once I got into it more, it became a routine for me. Somebody kept telling me that it was designed to make you fail. And at first I believed that because it was so hard, because like I said, I had to be there every day. And it's a difficult program. You have to be committed. You have to be willing to do the right thing. You have to be willing to do the right thing all the time. But like I said, you just adjust. Figure you're not gonna work because you gotta be there all the time. You're not gonna have time for your family because you gotta be there all the time, but it's worth it. The program has affected me after I graduated by giving me self-esteem, by teaching me independence, letting me know that I can do it even though I have mental illness.